Let's get started. All right, very good morning to our panel, panel 15, is it? Yeah. Yes. So we have our panel on digital trade, even though I realized this morning that they've changed the title of our panel to some emerging trends and challenges in trade agreements, isn't it? It was a last minute change I didn't realize, but I think most of us are going to focus on digital trade and the regulations surrounding digital trade. Because, we all realize that today we are living in a world where digital trade is going at a very hyper speed and the regulations are trying to catch up, but still they're so fragmented, they're so reactive and contradictory. So I guess, we're in a situation where we're in a problem where there's a disconnect, there's an asymmetry between innovation that's happening on the one side and the regulation that's supposed to regulate the innovation. And all the countries are sort of trying to chart their own paths, and that has caused a lot of legal patchwork that supposedly is sort of defining and regulating trade, digital trade for the time being. But that's leading us towards fragmentation, right? So, and so I think it'll be interesting to discuss whether fragmentation is really a problem. And is fragmentation the way to go when it comes to digital trade, or do we really need to sort of get some kind of coherence going forward? And I think our panel is really the one-stop shop to talk about this issue, because we're going to start with multilateral regulations. We'll have a look at what do we have at the World Trade Organization in terms of the regulations on digital trade. Then we'll get to plurilateralism, where we'll look at the JSI on e-commerce. And then finally, we'll have a look at the provisions in the regional and bilateral trade agreements. So we're really going to go in a full circle, approaching this from different angles. So yeah, the floor is all yours. I have Moshe, you're first. You will be talking about digital trade at the World Trade Organization. So floor is all yours. Each one of us, so these are the rules of the game. You all have 15 minutes. We had one cancellation, so instead of 10, you all have 15 minutes each for the presentation. And after their presentation, typical, I'll come to all of you for questions, for discussions, to make the session as interactive as possible.
Thank you very much. Just screen with the phone line forward. Yeah.
And if you can just start by doing the please.
Thank you very much. Okay, hello everyone. I'm Moshe Hirsch from the Hebrew University of Jerusalem. Hello everyone, good morning. I'm Moshe Hirsch from the Hebrew University of Jerusalem, and in the recent 2 years I work quite a lot on digital trade, which is a fascinating topic indeed. So I will mainly focus on the moratorium debate, but let me start with digital trade in general. One of the most important technological breakthrough that we have seen in the recent 2 or 3 decades is digitalization. I mean, the process under which we can convert physical goods into a digital format. And it changed significant swaths of international trade. For example, with regard to music, in the past we used to import tangible discs from abroad and hearing the music. And now we continue to import music, but we do it via Spotify, or Apple Music, and so on. And similarly, we can see similar transformation with regard to the move from tangible books to e-books, Kindle, or the transformation from physical games to online games. So because of this process, we can see dramatic increase of international trade in digitalized products. But the global digital economy is characterized by stark imbalances. And for this presentation, I think the most important thing is that close to 80% of digital exporters in terms of volume. Yeah, they are located in some, I would say, not so many developed countries, mainly United States, China, and some European countries, close to 80%. Yeah, and actually almost all developing countries that they are net digital exporters. Oh, sorry. Let's turn to the WTO law. We don't have many rules that are applied to all WTO members. And the most important one, it was included in the 1998 resolution of the Ministerial Council, saying that actually we are all the WTO members. In the next 2 years, we are not going to apply custom duties to digitalized trade. But we must bear in mind that at that time, 1998, only few products were digitally traded. So every 2 years, more or less, the moratorium has been extended again and again. And every 2 years, we have more and more digitalized products. So it means that actually the scope of the moratorium is expanding. Every 2 years, we have more digitalized products, and all of them are exempted from any custom duty under the moratorium. So we have the moratorium debate in the WTO forums and also in literature. And the most important question is it desirable to extend the moratorium or to make it permanent or finish with it? So I will present very quickly only the most prominent arguments of the two camps of WTO members. And let's start with the first group of states. They are in favor of terminating the moratorium, and this group is led by the largest developing countries, India, South Africa, Pakistan, Indonesia, and some other countries. These countries, they argue that actually under the moratorium, digitalized products, mainly from major developed countries, they enter duty-free the markets of developing countries. And it means that the developing countries, they suffer from lost tariff revenue. Yeah. And we know that developing countries, they rely on tariff revenue much more than developed countries. How much money developing countries are losing, it is not clear at all. There are very broad of assessments. They really vary widely, but it is clear that developing countries, they lose some tariff revenue. I believe that it is more important that the moratorium resolution actually limits the policy space available to developing countries. It limits the ability of developing countries to adopt some industrial policy measures to assist their infant digital infrastructure or digital firms. And we know that in the recent decade, major developed countries, they adopt industrial policy measures to adopt their digital industry. Now, moving to the second group of states, they are in favor of extending the moratorium or make it permanent. And I must emphasize that this is the largest group, or this is the dominant group in the WTO. It is led by major digital exporters, US, China, EU, Canada, Japan, and so on, but also few developing countries. So these countries argue in the WTO forums that free digital transmissions, I mean, without custom duties, it enhances productivity, innovation, competitiveness, and it's very good. And if we impose custom duties, it means that the prices of digitalized products will rise. And it would generate negative impacts for digital industries and consumers in both developing and developed countries. So actually, the main message here of developed countries, for you developing countries, it is also very good for you not to impose custom duties on our products. And the debate in the WTO is going on. And let me offer just a few critical remarks. First, if we examine the main arguments of the states that are in favor of extending the moratorium, we can clearly see that these arguments, they resonate with neoliberal ideology. I mean, again, if we remove trade barriers, it would be very good for productivity and competitiveness, raising standard of living. But actually, these arguments, they are almost completely detached from the reality, what's going on in the recent years in the international trading system. We talk quite a lot in this conference that in the recent years, major developed countries, they are increasingly imposing trade restrictions on their competitors abroad. So actually, while major digital exporters are imposing more and more trade barriers on their competitors overseas, they call upon developing countries to adopt neoliberal measures, give up all custom duties in this field. Perhaps even more important, I believe that we could think and adopt some alternative policies that can strike a better balance between the interests of developed and developing countries in this field. And let's start with cross-sector linkage. Yeah, it is a well-known technique in WTO and GATT negotiations. So it is possible, and I think it would be much better that developing countries would, indeed, they would be ready not to apply custom duties to digital trade. But at the same time, developed countries, they would be ready to decrease, reduce custom duties imposed on agricultural products, textile products, which are very important for developing countries. And second, with regard to different tariffs applied to different digital products. The whole moratorium debate is about a single question. Is it good or bad to abolish all custom duties on digitalized trade? But it is possible, I believe, to apply custom duties to some digital products and to abolish others. Just for example, with regard to digital products that they are essential for economic development, like software or e-books, yeah? Here we can abolish completely custom duties. But with regard to some luxury digital products, I think it would be much better to apply custom duties, as we do it in most other fields of international trade. So I believe that such alternative strategies can strike a better balance between the interests of developing and developed countries. Thank you.
Thank you so much, Moshe. That's great. So you've left us with two very concrete suggestions towards the end of your presentation, addressing a boiling debate at the World Trade Organization between the Global South and the Global North. And now from here onwards, we'll move on to the plurilateral perspective from the multilateral sort of debate and the dilemma about the subject. And Shivani Rajesh will take us through a very critical sort of analysis of the JSI on e-commerce with a focus on digital divide and digital colonization. The floor is yours.
Which one?
This is the previous page.
Good morning, everyone. My name is Shivani Rajesh. I'm from BITS Law School, Mumbai. My current research is on the analysis of the GSI negotiations, which are going on between countries at the WTO level. There is a dispute with respect to its validity under the WTO itself. However, considering that it includes a major membership of the WTO, it is something that I've been researching on. To introduce my research, I talk about the WTO Joint Statement Initiative on e-commerce, which I've taken up as a topic because I believe after the regional trade agreements, which have quite a few e-commerce regulations under it, the JSI poses to be one of the major, norm setter with respect to how digital trade would be governed at the international level. So it becomes imperative to look at what the JSI talks on and also to look at it from the perspective of whether it delivers what it promises. I look at it from the framework of digital divide and digital colonialism. Digital divide, which essentially discusses about the persistent inequality, not just in access, but also in the skills to use the digital technologies and the outcomes, in the sense whether you're able to use the digital technologies for creating economic output for yourself and therefore the country. So that's the framework that I use under digital divide. Digital colonialism falls as an extension of digital divide, because when there is a divide between people and country with respect to their digital abilities, it indirectly causes a hierarchical relationship between the digital haves and the digital have-nots, if I may call them so. So it's the modern form of dominance. We usually see this arising or taking place by technologically advanced entities over the weaker ones, the technologically weaker ones. The argument that I put forward in this paper is that without significant changes, adding certain provisions which aim to bridge the digital divide, the JSI by itself, relying on the stabilized text which has been released in July 2024, may not help in bridging the digital divide, but may in fact risk exacerbating the same. That is essentially broadly the discussion that I have. The first point that I tackled during my research was looking at this question, whether liberalization alone may lead to the bridging of the digital divide. Now, I looked at this question essentially because the stabilized text of the JSI includes certain terms which indicates that the aim of the JSI is to look at inclusive development, which essentially would include bridging of the digital divide. For instance, in the preamble, it is mentioned that the aim of the JSI or the text is to ensure inclusive trade and development. It includes references to the fact that there is the JSI would be helpful for consumers and businesses and especially MSMEs, which again to a certain extent discusses about the digital divide, because MSMEs would technically be the one who may not be digitally advanced in this context. So it feels like the JSI intends to do something about the digital divide. However, the provisions, at least based on the stabilized text, essentially discuss about enabling provisions, which means opening up the markets or facilitating the electronic contracts or recognizing electronic signatures, which essentially again leads us towards the liberalization aspect. It also discusses about issues such as e-commerce moratorium, which again intends to liberalize the entire digital trade aspect, not just on the digital transmissions part, but also on the content itself, as Moshe rightly pointed out. So that is the basis on which I started with this question. And in this question, I felt that there are two aspects to this discussion. One is from people who believe that opening up the markets itself would lead to bridging of the digital divide, because more people will have access to technologies, more people will use it, and therefore there would be lesser gap between the two factions technologically. This is very much in lines with the diffusion of innovation theory, and I've relied on this theory in order to make my argument, which was promoted by Everett Rogers. In this, Everett Rogers essentially talks about how innovation in any society diffuses across the society, and in which he divides the society into multiple parts, saying that in the initial phases of the technological innovation, there is the digital or technological haves who will have maximum control over the technologies, and eventually, slowly over a period of time, the entire population will have access to the same innovation. So that is essentially the Everett Rogers also says that the entire diffusion of technology follows an S curve, which is on a graph. If you track it, it would look something like this. So these are two separate points, but just to point out the fact that it will start with a group which has just initially started adopting digital technologies, and eventually it will lead to 100% of the population having access to that technology. Now, this cannot be looked at from a simple perspective, because when we track this across countries, we would have different countries starting at different points. For instance, a technologically advanced country like US would have started adopting digital technologies quite early on, whereas the developing countries or the low-income countries would have started using the technologies much later. So the groups that you can see are the different countries, or I mean, you can classify it as different groups of people whose starting point is different with respect to use of technology. Now, there are two ideas, or there are two opposing perspectives here. And when we say that liberalization alone may lead to the bridging of the digital divide, we are going ahead with the first understanding, which is the cyber optimists understanding, which essentially say that different groups of the population start the adoption of technology at different stages, but eventually, as the diffusion increases over time, there is a point where all of their access meets, which is the point of the point at the top. However, there is another set of understanding in this perspective, which is the cyber pessimists, which feel that when these different groups start using the technology at different levels, their difference will always continue to exist, irrespective of the time that the technology has diffused, over a period of time. Now, with respect to different innovations, this work differently. I feel that if the innovation is something which is a static innovation, for instance, television was discovered for the first time, maybe the first arc would be followed, that eventually, I mean, everybody will have television at different stages, and eventually the curve will meet at some point where all the population has television. However, I feel digital technologies, which forms the basis of digital trade, would follow the second curve due to the fact that this is a changing technology. The technology keeps changing at every stage and very rapidly, which is why even when the third group has started using the digital technologies, the first group has already undertaken advancement and has reached a greater stage of use of that technology, because of which the gap would continue to exist unless certain active regulations are brought in order to bridge that gap. I also look at the World Bank report of 2023, which kind of gives an understanding of various aspects regarding digital technologies in various countries. So we have the dark blue line, which is the high income country, the teal line, which is the upper middle income countries, then there is lower middle income countries, and the last one is the lower income countries. So you can see in case of internet penetration, there is a positive trend, right? It seems like the dark blue line and the green line would eventually meet at some point. They're going in the same direction. However, this is where the definition of digital divide comes into picture, because it's not just an access divide, it is also a divide in usage and skills. Now, I have used bandwidth and mobile broadband penetration in order to understand whether in these different kinds of countries, the usage and the skill is also the same or also following a similar trend. And we see that in case of bandwidth per user, which can also be considered as speed of the internet, the the arc of the developed countries or the high income countries is increasing at a much larger rate than all the others, including the upper middle income countries, lower middle income countries, and lower countries. So this essentially indicates that maybe internet is used by everyone, but the bandwidth which each person is using in different countries is different. Now, I use bandwidth in order to make a connection between the fact that when I use internet, which is, let's say, slow internet. Let's say I'm using internet where you have to connect the phone line to the laptop in order to get internet. I may not be able to produce economic output out of that digital technology as much as the high income countries would be able to. The same thing goes for fixed and mobile broadband. The trend looks similar, although, at least in the fixed broadband, the first graph is the fixed broadband. It seems like the graph of the upper middle income countries and higher income countries is going to meet at some point, like the cyber optimists talk about. However, the lower middle income countries and lower income countries are quite different with respect to their graphs. So based on this, what I conclude with respect to this question is that merely opening up the markets would essentially continue this digital divide, not necessarily bridging it, without there being some kind of active intervention in the policy making, where we try to ensure that the lower income and the lower middle income countries get to the stage where the high income countries are with respect to digital technologies. Now, in light of this, the core challenges for the developing countries when it comes to the JSI are largely these. The first one is with respect to digital colonialism and market dominance itself, which is currently existing in the international sphere. This difference in digital technologies and adoption of digital technologies leads to the late adopters, which are largely the developing countries, to act as mere consumers. Right? So opening up the market may not necessarily help the MSMEs and the businesses in these, lower and middle income countries as much as it would help them become mere consumers in the international trade sphere. In light of this, there is also something else that is very important, which is platform imperialism, which indicates the top technological giants of the world who control majority of the market power in various countries. So we have the GAFAM, which essentially controls 80% of the market with respect to digital technologies and digital trade across the world. And due to the peculiar nature of digital trade itself, because data becomes a major input in case of digital trade, it seems like their position as the market dominant entities would continue to remain as they have majority of the control over data at this point of time, being the first mover, having the first mover advantage. It hinders local competition and innovation as well. To take a few examples, for instance, when Uber started in South Africa, they were able to provide deep discounts by existence of global funding that they get, which the local taxi aggregators may not have the same ability to provide those kind of discounts, which leads to Uber capturing a major market control. So that would be one example. The second example is again in Africa itself with respect to the advertisement market, and I think a similar trend could be seen across all the countries, where 80% of the advertisement market is controlled by Google, 12% is controlled by Facebook, and the local advertisement industry has only 8% of the market with them. So we see these trends taking place across all countries, where a few technologically advanced entities are in a position to control the entire industry, which raises concerns with respect to what the JSI talks about. One interesting thing that I found in my research is about the participants' dynamics in the JSI. So we have the JSI where the conveners are Japan, Singapore, and Australia. These belong in the upper middle income countries. They are not necessarily the developed high income countries, right? So what would be their incentive? It would seem like most of these countries who promote promote such kind of rules at the JSI have essentially in the past undertaken similar rules under RTAs. So indirectly, they are just trying to promote something at the global level, what they are already agreed to do at the regional level. So nothing new which is happening for them. We also have a few developing countries who have participated in the JSI, which was a point of, discussion in my research, because if they are participating, it seems like they're open to it, right? However, the research which I recently looked at, which was conducted by Shamel Azme, where there is a research with respect to he has looked into the intentions of the representatives of these countries as to why they have joined the negotiation in the form of an unstructured interview format. Most of it seems like it's reactive joining, which means that most of these countries don't have the knowledge of regulating this industry within their country. So they try to participate in the forum, which gives them access to some knowledge about how to regulate it. And also because, learning from the past, they don't want to be left out of the negotiation process or the rule-making process, right? However, there are major capacity constraints which affect these countries in the form of capacity constraints with respect to whether they attend the negotiations itself, and also capacity constraints with respect to whether they are positively able to contribute to the discussion that is happening at the negotiation with respect to rule making itself. So that is also something that adds on to the challenge of the developing country when it comes to the JSI negotiations. From the JSI negotiations itself, the stabilized text, which was released in July 2024, due to various things that preceded has turned out to be a best endeavors mechanism, where most of the provisions do not impose obligations on the countries as such, but it's a best endeavors language. However, e-commerce moratorium is something that is an obligation that is undertaken. Again, in this context, in the light of the digital divide and digital colonialism, the moratorium poses to take away the power of the countries to help their own digital economies and to undertake certain industrial policies, as was pointed out by Dr. Moshe as well, with respect to protecting their domestic industry, which the international trade policy very much permits to do with respect to local protection of local industry. It again leads to the same aspect of dependency of the lower middle income countries over the high income countries, due to the fact that most of the internet users or technology users in these countries, the lower income countries, may be just consumers and not producers or economic generators themselves. Lastly, with respect to data sovereignty and policy space, this is a shadow provision right now because it's not been included in the stabilized text due to various political developments. However, it goes on to add to the same point of data extractivism, loss of jurisdiction for these countries, and also impedes local infrastructure and, has a harm of increasing tech dependency. So with that, I conclude the presentation. Thank you so much.
Thank you so much, Shivani. This was wonderful. I think this presentation reminds us every time we talk about digital trade, we do realize that digital divide is a big elephant in the room, and we do need to address the digital divide as a major challenge, which is embedded in the opportunity of digital trade, the opportunities that digital trade have to offer us. However, I've never realized the context, right, so far. And I think your presentation, your research findings have really contextualized the issue, the problem of digital trade, and made two things very clear: that it's not going to change. In fact, it's going to widen further if things are not done, positive measures are not taken. And two, we do not only need regulations or coherent regulations in the field of digital trade, we also need them. We need a more active policy intervention to directly address digital divide, right? Now, from here, we are going to move to the presentation by Ines. Here, Ines is here. And she'll look at another problem. And here we are now going to turn towards the way in which these fragmented regulations on digital trade, the provisions on digital trade, the agreements on digital trade have been drafted. So she'll have a critical look at the language, a very normative look at the language of these provisions for us in the trade agreements and the digital agreements. The floor is yours. 15 minutes.
No. This is the previous and this is the one I should piece, right? Yeah.
Okay.
Hi, hello everyone. My name is Ines Willemyns. I'm at Stanford University, and I've been working on digital trade for a while now, which I guess also means that I have my own ideas about international trade and where it should go. And I feel like this research project kind of was born out of that. So when I read the outcome of the JSI negotiations, or the stabilized text, whether it's the outcome or not is TBD, but I was disappointed for different reasons than Shivani was. But I was disappointed for two reasons. First of all, I wondered where all of the interesting provisions went. Where's the provision on data flows? Where's the prohibition on data localization requirements? Where is the provision, which I thought was very interesting, which we found in the negotiation documents, on expanding the scope of the telecoms annex and confirming that the internet is part of that or should be covered by that annex. So that was one concern that I think others shared as well. But then another concern was what is up with all this soft language in the JSI. Just to mention some examples, because I'm aware that not everyone knows the text of the JSI, which it's a niche part of trade, but still. So the language is interesting. So for example, in the provision on electronic transactions framework, the language says that the parties shall endeavor to avoid any undue regulatory burdens on electronic commerce. When we look at the provision on access to and use of the internet, the parties recognize the benefits of end users to have the ability to access apps and connect the devices of their choice to the internet. But that's it. And then a personal favorite of mine is the provision on open government data. I'll read it because I think the quote is important, is to the extent that a party chooses to make government data digitally available for public access and use, it shall endeavor, to the extent practicable, to ensure that the data is blah, blah, blah. As a contracts lawyer, you think, wow, this just does not commit me to anything. And I'm not a contracts lawyer, but still, I thought this is very soft. So where does all of this come from? Those of us that have been reading digital trade chapters, as well as the digital economy agreements, we recognize this language. This language is everywhere in these digital trade chapters. Or at least that was my presumption. That's how I kind of understood these chapters. But then I thought to myself, okay, maybe I should actually test my hypothesis that these chapters and these digital economy agreements are rife with the soft language. So I'd better kind of look into this and see whether that's actually the case before we can try to like understand why we got to this point. So that's what I did. This is part of a bigger research project, but the first step would be to just empirically kind of see what are we dealing with in all of these free trade agreements. What kind of level of commitments do we see? Is it a lot of soft language, or is there more hard language than I presume at this point? So what I did was I defined a taxonomy of the types of provisions that we find in these digital chapters, looking at their level of commitment. So I categorize as classification 1 is a binding and precise obligation. So an obligation that uses binding language that's precise in what it requires of the parties and therefore considered enforceable. A second type is, so classifications 2 are binding but imprecise commitments. So those are commitments where the parties say, the parties shall cooperate on, I don't know, consumer protection, but then they don't, the language itself is not precise enough to probably be enforceable when it comes to going to dispute settlement, for example. Or these obligations or commitments by parties that say we shall, or the parties shall maintain or establish a legal framework on consumer protection. Again, it's binding, the language itself suggests a binding commitment, but the obligations are kind of imprecise, so again, harder to enforce. A third classification are exceptions, exemptions, carve-outs, so any kind of limitations to obligations. The fourth type is these best endeavor clauses. A fifth type is recognition of importance provisions. And then there's a sixth REST category that contains definitions, clarifications, procedural provisions, etc. And so what I did is I used a large language model. So I used ChatGPT to help me do this classification. So I created a prompt where I explained to it, this is a classification that I'm looking for. I will give you the text of 182 free trade agreements. I want you to classify each paragraph that relates to digital trade according to this classification. Of course, I worked together with a computer scientist on this. I didn't do this on my own. And we cross-checked GPT's classification with what a human classifier would do. Spoiler alert, GPT is pretty good at this. It's also not difficult, right? This is not the high-level thinking. This is just language recognition, and a large language model is pretty good at that. So it turned out we could use GPT, which just saved us a hell of a lot of time. I don't have a lot of research assistants to help me with this. So I used GPT, but that worked pretty well. Okay, so now let's go to the findings. So my first aim was to, wait, I need to do it on this, yes. Okay, so my first aim was to confirm or disprove this hypothesis that over time, non-binding and hortatory language is increasingly infiltrating these digital trade provisions in free trade agreements. And based on the data, we can confirm this hypothesis. So what you see on the screen, it's pretty small, but I'll briefly explain. So the red line or the red dots are all the paragraphs in these free trade agreements that have binding language. The orange line and the orange dots are the binding but imprecise commitments. And then the blue line is classifications 4 and 5, which was if you recall, the best endeavor language and the recognition of importance. So the very soft language. So this basically just counts how many GPT could find in each agreement like organized over time. And so the left-hand side is absolute count. The right-hand side is the share per agreement. And so both show, I hope it's clear to everyone, both show that over time we see more and more of this soft language. So this is on a paragraph by paragraph basis. And why do we do paragraph by paragraph? Just because one article has multiple paragraphs and one article can have these different types of classification. And we wanted to see, first of all, just in general, how much of the soft language is around. But that, of course, only says one thing, right? Because we look at articles as a whole. And so as soon as an article has a binding commitment or a binding obligation, a classification 1, and it's surrounded by classification 4 and 5, so the soft language, we would still qualify that article as a binding obligation, right? Regardless of the fact that there's some soft fluff around. So we also, I also took a look at that. So this sets out different, I defined different article types based on the kind of classification that we find for each article. So article type A are those binding substantive obligations that are found just in and of themselves. No other kind of language in that provision, or only soft language with no exceptions. Type B are these provisions that have binding substantive obligations, but with an exception. And we decided to include, or I decided to include this because for those of us that have looked into these free trade agreements, many of them contain provisions on data flows, for example, or data localization, or prohibit data localization requirements. But then within that same article, they include this super broad exception for, well, for public policy objectives, you can also disregard the obligation. So we also wanted to include articles that have binding language, but then include a specific, like a subject-specific provision exception within that article. Type C, so the yellow ones are the binding but imprecise commitments. And then type D are the provisions that only contain soft language. So there's nothing else in that article, it's purely soft language. And so also looking at an article level, we see that there's an increase in these soft provisions, right? They are being included more and more over time, but it's not as exponential as when we looked at a paragraph by paragraph basis. So the article by article analysis confirmed the hypothesis, but also showed that that the explosion of soft language is not as extreme when we look at how many like different types of obligations have been included. So with this, hypothesis is confirmed, right? There's more soft language in these free trade agreements, but what does that mean? That's like the first step. And the second aim of the research, and the part that I'm still working on, is trying to understand what the inclusion of all of this soft language means. Because what triggers this interest in why is there so much soft language is that WTO agreements do not have that much soft language. WTO agreements are they're binding. 1 minute? Okay. They include a lot of hard language. That's why we like WTO agreements. They're enforceable. They say what parties can and cannot do. And then when it comes to digital trade, we seem to like be departing from this completely. So I'm still trying to figure all of that out. I don't have time to go through everything else, but I want to show that what I'm working on now, and I'm very happy to hear people's thoughts on this, is to look at it subject specifically. Like, right, when we look at e-commerce provisions, what kind of language do we see? When we look at non-discrimination obligations, what kind of language do we see? Because of course, dealing with different subjects will lead to different conclusions, right? We expect e-commerce moratorium provisions to be binding because, well, it's basically confirming whatever's happening at the WTO. It doesn't require parties to go much beyond what they're doing already. But then when we look at other types of provisions, so the provisions in relation to spam, consumer protection, paperless trade, personal data protection, there's a lot more soft language there, which is not unexpected because all of these provisions mainly deal with or request the parties to establish domestic legal frameworks, to protect consumers when it comes to digital trade, or to provide for personal data protection frameworks. And so the question is, to what extent can you make this binding? And what does this, and I'll leave it with that because there's many other questions I could raise, but what does that mean for trade liberalization when we move towards all of this soft language will it lead to changes in parties' behavior? Will it not? Why is there a need for so much fluff around hard obligations even? So even why do you draft a provision with a hard obligation saying non-discrimination of digital products, but then you add all this fluff that you recognize the importance of this and that and that. And so yeah, that is maybe a third and fourth and whatever step in this project. But I hope this already gave you an insight into soft law or soft language in digital trade chapters. Thank you.
Thank you, Ines. I think the history has already told us that language tells us a lot about the intention of the drafters, right? So the way provisions are drafted, the way rules are drafted and incorporated into policy instruments such as trade agreements, investment agreements, digital agreements, tells us a lot about how much intention, how much political willingness or appetite these countries really have to implement these commitments on the ground, right? The domestic implementation part. So yeah, promises and more promises, lack of enforceability, lack of specificity are real problems that all these, not just the provisions on digital trade, but every single new generation, incorporation of new generation issues like digital trade, like climate change, environment, inclusion, women, LGBTQ, indigenous communities, facing precisely the same problems. And from here, we'll move on to our last presenter today. And now for this final presentation, we have María Vásquez. And after this presentation, I'll open up the floor to our discussions with the presenters. And María will take us to a very specific yet pertinent topic about the non-disclosure of source codes in trade agreements and the dilemma around it as to how do we look at it, how do we demystify it, and how do we understand the transparency and the national security and other challenges surrounding this dilemma. The floor is yours, all yours, 15 minutes.
Thank you so much, and good morning, everybody. I must apologize, Donbass. It has been a tough night for me. I think jet lag finally hit. So if I miss something in the presentation, please come back with questions. All right, so I will be talking about a very hard provision in digital trade agreements, actually. Ines will be happy to know that this is really, really on your level A or perhaps B of digital provisions, is a non-disclosure of source code in trade agreements. So at the outset, just linking to the previous presentations, this is not included in the e-commerce JSI, right? So basically, why this provision? Why we have this this provision in digital trade agreements and digital trade chapters? Is basically there was this whole rhetoric around I think the year 2015 about concerns of technology transfer requirements, especially when we are talking about technological transfer requirements in countries such as China with the cybersecurity law that basically establish an obligation that you should disclose certain information before you can access the market. And you have to disclose this because it was in the cybersecurity regulation and because it was a technical requirement, basically. So in 2019, the OECD ran this survey and a workshop with policymakers, and they actually situated where source code stands in the areas of concern of technological transfer. And as you can see from there, it's really a problematic provision, or it's really a problematic requirement when we are talking about regulatory requirements to access a market. All right, so basically what this provision tells us that a country should do. And again, this is a very hard provision because it's namely a ban. You know, you cannot actually go soft in establishing a ban. You basically prohibit or not. And in this case, the prohibition is about any requirement to mandate transfers or granting of access to source code. And this is really linked to a condition for market access. You can see this language more clearly in the CTTPP Article 1417. It's basically no party shall require, the dream language of Ines, no party shall require. This is great. Okay, but there are many nuances here in this provision that requires further explanation. let's see how many countries have this provision in place. Actually, it's about 26 agreements that have this provision in place. The first one was a Japan-Mongolia FTA. It's not the CTPP, but I think it was at the same time that Japan and other countries were negotiating the CTPP, so it has been influenced because of that. And as you can see, there are many countries that are on this list, but surprise, surprise, we see that China is not in this list. So at the moment, RCEP only establishes, and it's the only agreement that establishes a cooperation provision, not even a cooperation, a dialogue provision on source code. And that is the only agreement that will ban China, but yeah. So we have this whole rhetoric that this provision was established because of the policies that were implemented in China, but China doesn't have a provision on source code. That is interesting. What is more interesting is the scope of the provision, because basically there has been a lot of critique, not only in the policy circles, but also in the literature, that the scope of this provision might be too broad because we don't know what is source code. It can cover algorithms, and in some cases, it covers algorithms. It can cover data, that's less likely, and it can cover application programming interfaces. So basically, the question is, what is source code? And to the frustration of many, those agreements do not define what is source code. So the only agreement that defines what is source code is the African Free Continental Trade Area Digital Trade Protocol. Not only that, but they also define what is an algorithm. If we take an indication that the parties of those agreements actually are very clear in inserting into the treaty, we are establishing this prohibition of not accessing source code. I think they are being very intentional in establishing this prohibition either for source code or algorithms. So I think it's very problematic to assume that when somebody negotiates an agreement on source code, it automatically will cover algorithms, because as we know, algorithms now are part of this field of artificial intelligence. They are included in products, also in services. So if you actually will have provisions on source code that cover algorithms and you cannot mandate a transfer or access or just looking at the algorithm, that might actually impede your regulators to look at algorithms. Now, this is a little bit on the type P of provision that Ines will say that we have this hard obligation, but there's a lot of bluff there. But actually, it's quite important in this case because we have a prohibition. So you cannot do things except in those cases. And those cases are the public policy reasons that are behind some of the exceptions and carve-outs in preferential trade agreements and digital economy agreements about source code. And here, my colleagues at the University of Lucerne, where I come from, basically wrote this really nice paper on regulatory autonomy on data provisions. And one thing that we also got us thinking is how this is happening with other provisions, right? And we know this regulatory autonomy can be looked through the horizontal exceptions and limitations that a digital trade chapter has. And one of those horizontal aspects is, for instance, government procurement. So what I did here is just to look at every source code provision and to see what's excluded. And government procurement is in 100% of the cases excluded. So if you would like to, for instance, impose certain requirements when you act, you do a public procurement of software services, you could actually include certain obligations because government procurement is just beyond the scope of this provision. There is another interesting case on the public policy exceptions that have been excluded, and this is the case of this exception to preserve or make available the source code for investigation, inspection, examination, judicial, administrative proceedings. So this is really interesting because basically here, what you will be allowing is the regulators to look at the source code and eventually to look at the algorithm. There are other interesting provisions, such as open source licensing. And here, what I think is interesting to note is that although I put here carve-outs and exceptions all together, of course, the legal value of a carve-out is totally different than the value of an exception. So this is just for exemplification purposes, right? I just wanted to show you what are the public policy reasons behind those. But of course, if you have a carve-out that's much broader, you are basically excluding many things from the scope of the article, whereas you have an exception, you might have to meet a legal test applied exception, and this is an ex post assessment. Now, I presented this paper earlier in Bristol. I see Gregory Messenger. I'm so sorry that I'm repeating this presentation here. But some comments in Bristol, and I've been presenting this paper in intellectual property symposiums, actually. And what got me thinking is that all the IP lawyers, they always look at me. So if you have all this, why do you have this source code provision, right? That would be a rational question to ask. And I'm coming from Switzerland, so it's like Swiss cheese. There are many holes. But so it got me thinking, and I thought, okay, let's look what will be the alternative regime to in international trade law to protect source code and algorithms. And that would be clearly the IP regime. And here, I think it's just very important to look at two provisions in the TRIPS agreement. One is the computer programs and compilation of data provision. And here, basically, what states here is that computer programs, whether in source or object code, shall be protected as literary works under the Paris Convention, which means that these should be protected as copyrighted works. Now, when this provision was negotiated, the idea was to protect source code. Specifically, and the negotiators specifically, well, we know the value of negotiations for the treaty interpretation. It's not that valuable, but still, they specifically try to exclude algorithms because it really doesn't make sense to protect algorithms as copyrighted works. And the reason is because when you protect something as copyrighted work, you protect it as a literary work, and a literary work has to be a written work. So I don't know if you understand source code as a novel, but under copyright law, they're basically the same. So that means that algorithms, because they are mathematical constructions, they are not novels, so they cannot be protected as copyrighted works. Now, I also thought, okay, but we have all those patent software implementing inventions, software patents, perhaps that could be protected under that regime. And again, this has been categorically, it's not impossible, but the European Patent Office and the USPTO have rejected many software patents because you have to prove a technical implementation behind the patent. This is what actually brought me to Bristol to talk with my IP friends there. And it's really not that easy. And it's very jurisdictional based. So you can actually not protect source code or algorithms under patent law. So, and this is the reason why I went to many of those IP conventions, because I thought like, yeah, but we have Article 39. So, and everything is trade secrets now. And trade secrets applies to a certain extent because the TRIPS agreement protects any type of information. And information is a very broad term. But there have to be three conditions so this information can be actually protected. It has to be secret, it has to be valuable because it's secret, and it has to be subject to reasonable steps to keep it secret. Now, if you think about source code, many of those codes are actually building up from open source licenses. So there you don't meet the first requirement, and immediately you don't meet the second requirement, and then you are not protected as a trade secret. But even if you were protected as a trade secret as source code or algorithms, what has to be protected of the obligation of the states, and again, these are very hard obligations in the TRIPS agreement, is that natural and legal persons only shall have the possibility of preventing the information to be unlawfully acquired by other people. So the TRIPS agreement actually doesn't establish a very high or compelling obligation of the states that you have to establish a trade secret law, you have to establish safeguards when for instance, the information is submitted to the government. There is not such obligation in the TRIPS agreement. So actually, if you're a company and you're not in the biotech or agricultural sector and you submit this data to the government, there is no obligation of the government to protect your data, except that we know that there are TRIPS plus agreements, right? Because TRIPS is one side of the story, but we have so many of those agreements in place now. And here I just went to the literature, actually friends of mine developed this, Jenny Subek developed this graphic, and the three aspects that has been protected in TRIPS plus agreements are patent, copyrights, and trademarks. And still, we know that they don't fit very well as a mechanism for protection of source code. What could fit is trade secrets. Unfortunately, because we have this database in the University of Lucerne, we also code trade secrets. And I am pushing for that because I really like IP. And what we see here is that the level of trade secret protection in TRIPS Plus agreements has actually not increased. It has remained at the TRIPS level, actually. So again, for the very seldom agreement between the US and an Asian country, namely China, there are no further obligations to protect trade secrets internationally. And this really goes along with the policy that the United States had before, because they were actually the main driver behind this trade secret improvement around the world. So they had in the WTO the Friends of the Trade Secrets. It was very secretive because I think I only asked a couple of people and they put me in contact with these trade secrets people. But it's that was soft law. That was a mechanism to promote certain best practices on trade secret protection. And in the context of the Asia Pacific, there was the APEC best practices on trade secret protection. But again, that was soft law, mostly replicating what is in the US law regarding trade secret protection. But nothing of that has been implemented in hard law, actually. Those are best practices, which means that we are left with the situation that IP really needs reforms, is inadequate to protect source code and to protect algorithms, which means, and I think with that I conclude, that it makes sense to include those source code provisions in digital trade chapters, despite all the backlash that exists at the moment against those provisions. But that also means is that we are really just obviating a problem here, is that intellectual property rights needs reform. And those reforms are not happening because there has been already a huge backlash against TRIPS Plus agreements. So what is going to happen, and I think what we call it is also this digital trade chapter, they have the gravitational power, and there is this domain shift to protect everything in the digital trade chapter. And we see that, but mainly because of the deficiencies in other regimes. And I think the example of source code and IP is just one of the examples of that. It might be that many things are included in digital trade chapters in the future because there is nowhere else where it could be included. Thank you very much.
Thank you so much. So we have seen a range of issues and a range of problems surrounding regulation of digital trade in this panel, in this session. We started from a look at the multilateral, sure, please. Multilateral perspective where Moshe took us through the dilemma between developed and developing regarding moratorium. Then Shivani took us through the digital divide issue, where we saw that digital divide is such a huge problem that's going to remain and continue very much, and in fact get worse if we don't do something actively about it. We had Ines take a very critical look at the way in which these provisions are being accommodated in the policy instruments, so to say. And then finally, María, who took us through source code. And even though Ines in her presentation talked about the challenges of non-specificity and non-binding nature of the provisions, we saw that other provisions, other kinds of provisions, even though they are super binding, could also lead us into challenges, different kinds of challenges. So the floor is all yours. Floor is open for questions. And you can just raise your hands and I'll walk to you.
Thank you. Wonderful panel. I enjoyed every of those presentations. That's why question to everyone, actually. So I start with Moshe. Your suggestion to take the agricultural trade negotiations back. I can, yeah. So you suggested that we should look at relooking at using agricultural trade negotiations to maybe give in. So first of all, I find it interesting that you said removing the customs. So that means you assume that there are actually customs applied to digital products, which is interesting because it's true with all the digital service taxes. And then I'm a bit concerned about this because, I mean, developing countries, specifically also African countries, for years have tried to remove agricultural tariffs more. And now when they're actually trying to use digital trade as a tool to maybe use the potential as well, this is a suggestion that I would find a little bit tricky. Also now the AFCFTA Digital Trade Protocol has put actually a legal system in place with rules of origin and where actually the possibility of custom duties on digital products would be a possibility once the moratorium is expired. So I'm a bit concerned that we're now going back and put them into place and say, look at agricultural and redoing the digital trade. Just a concern. To Shivani, very interesting. I just wanted to ask, you say that the countries say that they basically just do agree already at the GSI level what they have done on the regional level. But in some instances, like with the customs moratorium, that leads me to it, they actually contradict that then. So because they agree now on the GSI level, that means they nullify exactly what they wanted to achieve as a preferential trade at the regional level. So that's put to you. Ines, very interesting. I would like to see the data at the very end, what comes out. Just have a comment on, is it maybe that fluff, what you can't explain, is it maybe just political economy in negotiations when we are at the African level, they all just disagree with everything. And then in order to get them to agree, you just say, okay, just put that at the end. So what I learned there is just to look at the obligations and just ignore the rest because it's just to appease someone so that they feel okay. So it's just a consideration. And to the last, Maria, yeah, source codes, extremely important topic, very underrated. I just wonder if you have looked at the IP protocols at the regional level. So you spoke about the TRIPS, but there are a lot, like in the AFCFTA we have that, but also in other regions we have that. So are they similar provisions like the Article 39, or are there possibilities to maybe where they go TRIPS plus, because you mentioned TRIPS plus? So question to everyone.
Thank you. Thank you. If you don't mind, we'll take a few more questions and then I'll come back to you for. So.
I have a question for Shivani. Very interesting presentation. Just wanted a little point of clarification regarding the innovation diffusion theory you talked about. It seemed to me that the first mover advantage works, especially in case of imported technologies. But as an example, how would you explain success of UPI in India, which has actually hampered competition with MasterCard and Visa? So it's actually bridged the digital divide. So how would you situate that within the framework of your research? Thank you.
Sure. Thanks so much for the brilliant presentations. I have two questions to Moshe and Ines. So Moshe, how do you think then that the solutions that you're offering relate to the current challenges we're broadly facing with WTO negotiations? Because a lot of it seems to basically depend on whether we can have a single undertaking if we simply try and go with your first option, or in the second case, well, we again need to have broader membership input to see how we're going to split which tariffs will, which digital goods we can focus on and have tariffs and which ones we shouldn't. And I'm actually quite curious about what are some of the hypotheses you might currently be thinking about to explain some of this soft language. It might well simply be that because you focus again on maintenance as being one of those hard obligations, maybe pushing for stability whilst promoting some change. It might simply be to allow for some space to get through those negotiations in domestic parliaments, perhaps. So maybe that two-level game could be an interesting thing. That's just my own hypothesis so far. Thanks.
Do we have a few more questions?
Sure. I'd like to have thank you, the presentation, the other presenters are so marvel. And I have a quick question to Ines. I'm quite interested in how the soft law can actually work, and is there any contingency between the content and the binding force? For instance, although the language might be soft, the commitment might be more detailed, and the obligation might be more specific. So the country might not want to have that strong binding force, but instead there's a way we'll do A and B and C and D that somehow is a substitute for a strong and binding obligation, especially in the current political circumstances. Would you think as a better alternative instead of just go straight forward to very strong binding forces? Thank you.
Thank you so much. Final question by Wolfgang. Thank you. Any final burning question there? All right. And then we'll come back to you.
Okay, thank you. I have a question for Shivani, and maybe it's the same question for Ines, because I think that you, Maria, at some point, and another question to digital divide, and I wonder what your thoughts are about all those provisions that were removed or not added in the stabilized version of JCI. Do you think that they add to digital divide or otherwise? Because I think that their intention is to further digital economy, and that's the part when I would like also to hear some comments from Ines. Because you mentioned that you were disappointed that they were not in the final version. But the question is whether it's good or bad for digital divide. And I also have a question, or rather a thought, or maybe it will give you a point for all those things you didn't have time to add. Did you look at parties that are part of digital chapters and digital agreements? Because I think that more countries, more states are involved in this chapter. They tend to be more fluffy and less enforceable. Because it's just you have to add digital chapter to your RTA, even though you don't want any commitments there. But also, really long time ago, I compared RTAs concluded by US and EU, and it's not true that all RTAs are enforceable. They has this tendency of adding lots of words and not so many hard obligations in their RTAs. So maybe that's also some path forward. Okay, thank you very much.
Thank you. So, dear speakers, you have 2 minutes each for responding and concluding thoughts. Let's go ahead.
Should I start? Okay. Thank you so much for the questions. This is actually very interesting. With respect to the UPI in India, because it's close to my heart, so it took a long time for me to understand the impact of digital divide myself, coming from India, because India is actually an outlier in that entire group of countries. With respect to UPI specifically, the point that I would like to make is with respect to the fact that considering that the technology is rapidly developing, it becomes imperative for us to completely understand the the impact that it has, the negative impact, as well as the benefits or the advantages that it can provide to the society. So for instance, European countries don't have the UPI because there are a lot of privacy concerns with respect to its application. And a few years back, one of my students were researching on that. So essentially goes on to say that maybe India had the advantage with respect to the UPI infrastructure, probably because back then we did not have a privacy regulation. So goes on to say that a lot is changing in the technological sphere with respect to the impact that it has on people, as well as the opportunities that it produces economically. The point being that undertaking obligations at the international level at this stage without understanding the full potential of the technology, impact and potential, is something that needs to be looked into or needs to be thought of. So I completely agree with you that UPI may not necessarily fit in this theory. However, I would also like to say, and I myself took a long time to come out of it, that India is an outlier when it comes to developing countries doing good in the digital sphere. With respect to leapfrogging, again, this is a very interesting discussion that I read in one of the papers which discusses diffusion of technology, innovation theory, that leapfrogging could probably help when the technology that you're looking at is stagnant. So that's why I gave the example of, let's say, when television was first introduced. As an innovation, television could be considered as something which is a stagnant innovation. Obviously, there is flat screen, there's the big, television that we have. But just the fact that access is kind of common for all. I mean, I wouldn't say that a flat screen is different from the bigger television that we get. However, with respect to digital technologies, especially which contribute towards economic output, because of the changing nature of the technology, I agree that leapfrogging is something that does happen, but it doesn't necessarily bridge the divide, because by the time we have leapfrogged to that position, the developed countries have already gone, 10 steps ahead with respect to the technological developments that have taken place there. So again, leapfrogging to a certain extent doesn't solve the problem of digital divide, but I agree with you that the time it takes for the technology to diffuse in developed countries may not be the same as that for the developing countries. As with respect to the deleted provisions, I just take 30 seconds. I believe, again, going back to the point that I made for UPI, that the potential and the impact of digital technologies at this stage is quite open-ended. I mean, I think over the period of 4 years, so many things changed that multiple developed countries also realized the things that they're getting into and probably backed out of it. So that's why probably, take it slow is what I would say. Yeah.
Yeah, I will be very quick. Yes, I look at the IP protocols in the ACTA, but I also look at all other IP chapters, honestly. And there is room for improvement, clearly. And here I'm not making a lot of friends because, it's really not fashionable to say that you can renegotiate TRIPS Plus agreement for the better, not for the worse. But for instance, one possibility for enabling some sort of disclosure of source code is, for instance, having a clarification in what is an unlawful disclosure in trade secret provisions. And here, for instance, when looks at the US agreements and the EU agreements, they basically say reverse engineering is allowed. And nobody looks at that, obviously, but it's allowed. So you can also clarify that for public policy reasons, you could actually, open the source code or open technologies. And this applies to all trade secrets, not only to source code, obviously. But we don't see that that's happening. And when I tend to ask the IP negotiator is that they never talk with the digital trade negotiators. So there are two different communities that they don't talk. And perhaps that's why this gap is widening. But yeah, they are underutilized. Thank you.
Thank you. First, with regard to the link between agricultural products and digitalized products, I fully agree. They are very, very different. But I think that when some countries have a comparative advantage in the production of some good, they want to have free trade, not custom duties at all because I'm stronger. Yeah. So with regard to agricultural products, we know that most developing countries, they do have a comparative advantage in this sphere because they have cheap labor. But once they want to export it to the EU, United States, Europe, and so on, they face very high tariffs. And we know that there are some non-trade concerns. And while we are talking about digitalized products, it is just the opposite. So I think that it would be good to adopt this technique of linkage and to have a better balance that developing countries will not apply customer duties to digitalized products, but developed countries would give this concession of significantly reduced tariffs imposed on agricultural products. Seems to me a fair solution. With regard to the second question, the single undertaking, I think it is possible that there are many products that they are included in the single undertaking, but we have different tariffs. Cars or agricultural products or textile products. So it is possible to have such an agreement as a covered agreement in the single undertaking, but different digital products will get different tariff lines. I think it's possible legally. Thank you.
I can use this one. Thank you so much for the questions. I will not be able to address all of them in the 2 minutes that I'm given, but I think many of them kind of point to the same thing. So talking about the hypotheses of why there's so much soft language, I think, well, first of all, the fact that it's political, I completely agree. Yes, this language is included for political reasons, but I do think we can still question whether it's appropriate to have so much soft language in these provisions. So there's absolutely this political angle, and indeed, when you look into the parties that have included soft language, we see this evolution of more digital trade agreements, because indeed everyone seems to have this thought that, okay, you can't have a trade agreement without digital because your country is embracing digitalization and it's part of well, it's just hip. I don't know. It's cool to have digital trade agreements, but that's why I get so frustrated, because governments make all of this noise about we have another digital economy agreement, but then when you look into the agreement, there's not that much in there. And I think maybe it's a personal preference, but I like treaties to be clear and succinct and binding. And that's not to say that there's no place for soft language. I'm definitely not advocating for digital trade chapters to be binding across the board, all strong commitments. I do think there's a time and a place for soft language, but the sense that I get from looking into this is that it's more like haphazard, like whatever, like we'll just include that we think this is important, but not do anything with it. And I think for the sake of clear treaty drafting, I think we can kind of question why countries make that choice. And that is why I think, especially looking at the JSI, it was frustrating to me to see this soft language, because it's okay not to agree. The negotiating this is very hard. And when we talk about the digital divide, yes, maybe we shouldn't have a very comprehensive agreement on electronic commerce. Sure, I'd much rather prefer that than this language, where I feel like once we get to the point where this is concluded, where this is adopted, will it ever be updated and made stronger? I think from our experience, probably not, because renegotiating is very hard. So I don't have the answer, but I do think it's important to question the evolution. Points taken on things to do in the future. So path dependency, I did look into it a little bit. For some provisions, you see that it's evolving towards hard language, but not for all. So there's more work to be done there. And as to the parties that are part of these agreements. I haven't looked into that more. Also because a lack of data. There's a lot of FTAs with digital chapters, but ideally in these like empirical frameworks, you want much more data. So that's kind of, it's not easy to, okay, and I'll leave it at that, but I'm very open to any kind of questions or comments, or I'm happy to share the paper once it's ready. So please do reach out. Thank you.
Thank you so much. We promised you a one-stop shop and we delivered. Please join me in raising a round of applause for my dear, brilliant panelists here. Wonderful presentations. Congratulations.
Yes.
Yeah, let's do it.